Good day, and welcome to Epstein Becker Green's webinar, How Should My Telehealth Business Be Structured?, part of the Telehealth and Telemedicine Crash Course webinar series. Before we begin today's presentation, please be informed that today's webinar is being recorded and the participant phone lines will be placed on mute throughout the program. In approximately 2 to 3 business days following the webinar, Epstein Becker Green will communicate the availability of the webinar recording and access to the PowerPoint materials. We are pleased to have a fantastic speaker today. Bradley Davidsen is an associate in the Healthcare and Life Sciences practice in the Chicago office of Epstein Becker Green. Mr. Davidsen, an attorney in the telehealth and telemedicine practice at Epstein Becker Green, advises clients on corporate practice issues and the research, development, and approval of pharmaceutical and medical devices. At this time, I'd like to turn the webinar over to Bradley Davidsen.
Thank you, Whitney, and good afternoon, everyone. Thank you for being here. So I know you're going to get these slides, so I'm going to move through them pretty quickly. Basically, I set up 3 questions that you should always be asking about your telehealth model and how to make that business feasible. But I'm probably not going to stick to those questions very much, even though that's how the slides are kind of broken up, because those questions are really interrelated. And a big question, or a big thing to realize is that for your telehealth model, it might be fine from state telehealth perspectives, but that doesn't mean that you can practice that model through a general business corporation. You might, but if you have corporate practice prohibitions, then you're going to have some problems that you need to work out. So those 3 questions generally are, what is corporate practice? And what's the kind of scope of corporate practice laws? What do you do when you have a corporate practice law that's in place within a state? And how do you generate revenue back into a management company, which is almost always going to be the model that you're following in those corporate practice states? And the kind of takeaway that I want everyone to have is that understanding the state corporate laws and corporate practice laws and telehealth laws, understanding that up front is going to give you the kind of flexibility and maneuverability that a lot of other companies don't have, because they're locked into something and they're realizing, boy, we should have done this research a couple of months ago, maybe a couple of years ago. And even to the extent that you have a business that is already moving forward, you still need to ask those questions when you think about expansion. So Whitney, can you go to the next slide? Okay, so what is corporate practice? Generally speaking, it's a prohibition on employing healthcare providers, and I use the term healthcare providers instead of physicians because even though we all think of corporate practice as corporate practice of medicine, there are other corporate practice laws for different professions, nursing, optometry, etc. And sometimes the corporate practice statute will say medicine, but it will define medicine to cover a whole bunch of different professions. So you really have to read the prohibition within the state, and also understand not every state has prohibitions, or if they do, they may not affect your business. For instance, if you're doing telebehavioral health and you are not prescribing, you may not need the services of a psychiatrist. And in that case, you may not be affected by corporate practice laws. So you really have to do the kind of research in that state to figure out whether they even apply. And if they don't apply, you can ignore the rest of the slides. But do laws vary by state? Yes, they vary dramatically. But even in the most restrictive states like New York, California, Texas, there are usually carve-outs for employment of physicians or others by hospitals or HMOs or other healthcare entities. And throughout today, I'm going to talk about physicians. It's just part of my vocabulary. I'm going to use that term a lot, but I really mean professions in general because, as I said before, it's not always just the corporate practice of medicine. It could be any of a number of professions. And I gave you an example of a corporate practice law. This is Texas, which has a pretty thorough and strict corporate practice law, and it basically prohibits a corporation or anyone but a licensed professional from advertising or in any way endorsing or providing services or saying that it's providing any kinds of services unless it's licensed to do so. On the next slide, we see that I'm basically already going out of order. I'm answering question number 2, just act surprised when we get there. But the answer to the corporate practice issue is almost always that you create a management corporation and that you have friendly professional corporations that contract with that management corporation to provide those services and have the revenue flow through. So in states where you have corporate practice laws, that is what's going to drive you to use the professional corporation model, although you could just choose to use that model regardless of corporate practice laws, but we're talking about corporate practice. So when you have these professional corporations, you have 3 kind of hurdles. First is ownership. Almost always in a PC, the only owners or shareholders of the PC are going to be the licensed professionals who are practicing on behalf of or as an employee of the PC. Sometimes you can get non-professionals to serve as officers or directors, but I would say that that's less likely than likely. Profit sharing, you often will have statutes that are very explicit to say that no one but a shareholder may share in the profits of the corporation, or if it is permitted, it may be limited by a certain percentage, and the decision-making. And I know this is maybe one of those instances where people say, well, yeah, of course, I get it. A corporation cannot tell the PC or any of the professionals within the PC how to make their professional decisions. You can't tell the PC or the physicians within a PC what patients to see, how to see them, what testing to use. So that's maybe a of course kind of moment, but that is also where a lot of the power for state regulators and for prosecutors and attorneys general to enforce those laws. That's what they're focusing on in a lot of suits, and that moves into the what can happen if you violate these CP statutes. In some states, it could be a felony. You could also be charged for aiding and abetting, and in those circumstances, they're usually going after the professionals or the PC, and then they bring the corporation or the general business corporation, here we're talking about management corporations, they bring them into the suit by pleading aiding and abetting. If you're convicted, it could be fines or imprisonment, and for professionals, they could lose their licenses. And if you want a good example that's publicly available, you can look at Aspen Dental. It's from, I think, June of 2015 out of New York. They signed what's called an assurance in New York, but it's basically a deferred prosecution agreement. And it lays out all the things that they were doing, which in New York were impermissible because they have corporate practice laws there. However, I think it's good when you review that to understand that every state is different, and not everything that was happening between the management company and the individual PCs that are discussed in that case are necessarily illegal everywhere. That could be permissible in other states. And on the next slide, we talk a little more about how you administer that relationship. So you've got your management corporation, you have your friendly PC, and you'll, whenever possible, in almost every state, I think, allows for management agreements to exist. You're going to have a management agreement that breaks down the relationship between the two entities. And in normal circumstances, you're often talking about administrative services that are being rendered, maybe, billing forms and practices and HIPAA consent forms. You're also going to have maybe SOPs that like a physician practice does not want the headache of putting together, but they're very, very happy to have the management corporation provide them and make edits here and there for them rather than have to do it all on their own. But within the telehealth space, you also have the technology aspect, and so you're going to have additional services related to the technology, the maintenance of that technology, and the kind of troubleshooting that you'll have with the technology or licensing to that software. So even when you have a management agreement, you're still limited. You still can't state within the management agreement what patients will be seen, how they're treated, what tests you use, and what conditions the patients have to have, et cetera. And most of the time, you're limited so that the general business corporation or the management company, they can't provide any kind of advertising on behalf of the PC, or if they do, a lot of times those statutes are very specific as to how to advertise and exactly what can be within the content of those advertisements. But the other piece of the relationship that is sometimes prohibited in some states and sometimes heavily restricted is called the stock transfer agreement, and that is an agreement between the management company and an individual shareholder, which talks about the control of the stock based on predetermined circumstances. And, you know, those are always going to be circumstantial, not to use the same word twice, but there isn't a lot more detail I can give you without circumstances. Do you want to move on to the next slide, Whitney? And the legal revenue streams, I mean, this is incorporated in everything that we've just been talking about, because if you weren't able to have a revenue stream, you wouldn't perform the business. You know, you wouldn't put it out there. So how do you get money to flow back into your management company? As I said, you know, you can have restrictions on profit sharing, but some states will allow a certain percentage for administrative or non-professional work. And in other states where you have corporate practice limitations and you can't get a percentage, you have to look at fixed fee and cost plus models, and within that management agreement, you might have, you know, fees for the use of the software or licensing payments, something like that. Ownership of shares we kind of just talked about, especially in relation to the STA and how it is used. So I'm just going to skip over that and move on to my last slide, which I want to spend more time on. And this is knowing your business model. What we talked about today was how to set up corporations, but how you set up those corporations and how those entities interact really depends on what you're doing, and really fully understanding your telehealth laws within the states, one, where you want to be in today, and two, where you want to be in tomorrow. The whole telehealth, telemedicine space is evolving so quickly, and we're trying to keep up with it, but it's imperative that companies keep their finger on the pulse of what's happening, because everyone's going to have an expansion plan, and if you move too quickly into a state and you're not prepared for it, you could have some pretty dire consequences. So you want to make sure that you're moving at the right pace for your company. And actually, there are a couple of additional issues that are going to be covered in some of the upcoming sessions, which relate to licensure and other kind of risks and prescribing. So these are all questions that you have to ask. Do I want to prescribe through my telehealth venture? If not, you know, what kind of care am I providing, and where are the hurdles or the stumbling blocks in each state? To what extent can we jump over that hurdle by providing the care through non-professionals? And this is, I think, a question that a lot of practitioners or rather businesses should be asking. A good example is the telebehavioral space, where at the very top you have psychiatry, which is heavily regulated and is going to fall under most CPOM statutes. So in those states, you've got to be very careful about how you set up your business models. However, if you can provide the majority of your services through non-professionals, through counselors or through other individuals, even nursing in some states, it's not covered under CPOM, and it doesn't have its own separate limitations. So in those states, you may want to offer your professional services as an add-on instead of as an integrated central part of your platform. And once you figure all of that out, that's when you decide your corporate models and your structure and how you want to move forward. So hopefully you will dial into those. I know Whitney's going to talk about them, but it's all pretty integrated, and I appreciate your time today talking about this, and please let me know if you have any questions. Thank you.
Thank you, Brad, and thank you to everyone who's joined us. This does conclude today's webinar, but you're welcome to submit questions directly to Bradley Davidsen at bdavidsen@ebglaw.com or using the phone number displayed. In approximately 2 to 3 business days following the webinar, Epstein Becker Green will communicate the availability of the webinar recording and access to the PowerPoint materials. As Brad mentioned, we do have upcoming installments in this webinar series. We hope that you'll join us. They're taking place the next 2 Tuesdays in July at 2 p.m. Eastern. For additional details or to watch recordings of previous webinars, visit www.ebglaw.com/events. Thank you very much.